Hi everybody and welcome back. This lecture is going to be a little bit longer of a lecture than normal, and so just know that going into it. First of all, here are all the readings for the lectures. Again, make sure you read all of these and make sure that you understand all of them well. So this whole lecture is going to be about lawyers, and it's kind of ironic actually when you think about lawyers, right? Some of you listening to this lecture might even have a desire to be a lawyer when you grow up and stuff, and so this will be a interesting lecture for you. But probably no other profession have simultaneously been subject of honor and vilification to the extent that lawyers have, right? They're either seen as these champions for justice or as these despicable villains that are just out to make a buck, right? And this module is going to look more deeply into the role of the lawyer in our adversarial system and consider the evolution of law as a profession, and also very specifically look at education of lawyers and how we educate lawyers and how that may or may not actually play into why lawyers are viewed this way in general. So for the evolution of the profession, right, the law is a learned profession, right? And that's something that is important to note, is this is a learned profession. The law is not something that you can just feel, right, or it comes natural, right? It is a very, very educated profession. And part of that profession is a professionalization into that profession. And this is kind of an attempt to translate one type of resource into another, right? And so we have this specialized knowledge or skill that becomes social and economic rewards, right? And if you think about it in general, and we'll talk about this, more in the future, but when you hire a lawyer, what service are you getting? Are you getting something back from them? When you hire a doctor, you might get medicine or surgery. If you hire a plumber, you get your pipes fixed, right? And there's some sort of tangible thing that you can see or touch that you get in return for hiring pretty much every other profession but an attorney. The only thing you're getting when you hire an attorney is knowledge. You are paying for their knowledge of this abstract idea. And the smarter the attorney, the more it costs to obtain that knowledge. One of the things that's also interesting about law is that they have complete market control, right? The successful assertion of market control, just in general, is the successful assertion of unchallenged authority over some area of knowledge and its professional instrumentation. But how is market control asserted in the legal profession? Well, the body of knowledge became far too much for any ordinary person to handle. Before that, there was no need for a legal profession. Now, if you want to represent yourself in a trial, which legally you can do, you're viewed as a crazy person, right? Because there's no way you could possibly know and understand the law without having a professional who spent years to the study of law assisting you. Now, to become a profession, any discipline has to have all of these things, right? There has to be full-time occupation. They have to have established training schools and typically university affiliation of training schools. Local professional associations are typically started, as well as national professional association. State licensing must exist, and formal codes of ethics must be established. And if you think about that, this is the difference also between going to professional school or graduate school, right? Graduate school are master's degrees and PhDs. Professional schools like pharmacy school, PT school, law school, medical school, they all have these kind of aspects to them, right? So we're going to take all of these 5 major points and discuss them in a tremendous amount of depth, right? So we're going to start with becoming a full-time occupation. In primitive societies, lawyers didn't exist. There were no needs for lawyers, right? Judges and courts were temporary, so judges and courts didn't even really exist. But the development of the legal profession has been intimately connected with the rise of legal systems, right? As societies become more complex, as societies develop more of a need for a more concrete legal system, there was a need for lawyers. In the 1200s, the profession of the advocate, a regulated group of law practitioners with training, emerged, right? And the first lawyers were actually trained by judges in the courtroom, right? And so the judges said, here's how I want you to represent your side. Then, training moved out of the courtroom into these things called inns of the court in England. And members of the inn became organized and monopolized the training of lawyers. They figured out, instead of having a bunch of different areas, only inns of court should be recognized by courts. And so they kind of have this monopoly on the training of lawyers. If you think about it, right, law school is pretty much a monopoly on the training of lawyers, right? You cannot be a lawyer without going to law school. That didn't used to be the case, and there's still a couple exceptions, but overwhelmingly, you have to have gone to law school to be a lawyer now. Within America, in the American legal profession, pre-revolution, law was practiced exclusively by the upper class, right? The wealthy sent their sons to the Inns of Court, and lawyers were viewed as largely unpopular because they represented the crown and were only available to these wealthy people. During the Revolution, many lawyers left America and went back to England because they were loyalists. They represented the crown, and so they wanted to get back to the crown. They were not going to do well in a society that didn't respect the crown anymore. Post-revolution, the legal profession became significantly more egalitarian. It was no longer just the upper class rule. So again, we've talked about all these things, right? So that's how law became a full-time occupation. Now, we're going to move on to having established training schools here for a profession, right? What are these training schools? Obviously, they're law schools, right? In the 1770s and 1780s, the first law schools were established, and they grew out of a specialized law office offering an apprenticeship program. And it was a 14-month program, there was no diploma, and it was taught by lecture method. There may be a lax oral exam required, but maybe not. And it was pretty much like plumbers or electricians or any other profession has apprenticeship programs. It was the same thing. Eventually, university law schools started popping up, but it pretty much remained this way until the 1870s. It wasn't really until the 1870s that teaching of law began with a case method as opposed to a lecture method. Law school admission standards also started to change in the 1870s with the advent of this case method. And where we are today is that law schools, again, are gatekeepers to our legal profession, and we all know that, right? You're not going to become a lawyer if you don't go to law school, overwhelmingly. In almost every state, law school education is required for admission to the bar. Now, what's important to note is you can graduate law school, but not be admitted to the bar, so you still can't practice law, right? Just like you can graduate medical school and not pass your medical boards. 7 states have provisions for reading law programs that are like apprenticeship programs, but the American Bar Association opposes these programs and restricts practice of these lawyers to their home states. So if you did do this reading law program and got admitted to the bar, you could only practice in your home state, as opposed to someone who went to law school that could potentially sit for the bar in other states. If you look at the enrollment, right? In 1963, there was only about 50,000 people enrolled in law school. In 03 and 04, which is a while ago, that number had tripled, right? And so what we're seeing is this huge growth in lawyers, which some might argue is not necessarily a good thing. Historically, law students were dominated from better educated, more affluent white families, right? If you think about it, that kind of makes sense, especially with segregation and Jim Crow laws in America. In 1970, only 8.5% of law students were women, and only 3% of law students were minorities, whereas in 2003, 50% of law students are women and about 20% of law students are minorities. Now, the Socratic Method is the method that's used in law schools today, right? Law was a general science, and its principles could be experimentally induced from the examination of case materials, right? And so case books became textbooks, right? And generally, the Socratic Method involves an intense interrogation by the teacher of individual students concerning the facts and principles presumed to be operative in a particular case. And the objective here is twofold. Number one, it's informational, right? So we instruct you on the rules of the law. Like, look, here's an opinion that tells you what the rule is. But also, it helps students think like a lawyer in the sense that you are having to use other cases now to back up your argument, right? So not only it's like, do you read a case and say, I see what the legal rule is here, you now have to use other cases similar to that to prop up your argument, just like you would have to do in a lawsuit or in a summary judgment motion or a motion to dismiss or something, right? So there are some strengths to the Socratic Method. Large class sizes are possible. You guys clearly, if you guys didn't read for this online class or if you don't read for your in-person classes, you can largely get away with it. And there's only 20 people in the class, right? And you can largely get away with it. We've all seen Legally Blonde, I'm assuming, and you figure out pretty quickly in law school that if you don't read or you're not prepared for that day, and you happen to get called on, it's going to be a very, very bad day for you. And so even if there's 100 people or 200 people in the classroom, everyone pretty much comes to class prepared for the class, and they learn the material prior to getting to class so they don't look stupid in their class, right? And so another strength, again, is that it requires a student to prepare for class and learn the material. It also focuses the student's attention on subtleties and provides a good background for logical reasoning, right? You have to pay attention to these subtle little things because you might read the case and say, oh, clearly this case was about someone who fell in a hole. When actually it was about premises liability and about how the owner of the land where the hole was had a duty to the person to actually fill in that hole. Or duty to the public in general to fill in that hole because it might be viewed as an attractive nuisance, right? And so it focuses your attention down to these minor little details as opposed to looking at something broadly in general, right? Now, obviously, there are criticisms of the Socratic method. The classroom environment is considered a hostile environment and creates a very intense emotional environment. I've taken a class or two at the law school at UF as electives when I was getting my PhD, and there were several people that would cry during class. There were people that would walk up to the door of class and say, I can't go into class today, I'm not ready, and just skip class altogether. Students also complain that the method is inconclusive, right? It doesn't really give you a strict answer. The answer to every legal question ever is, well, it depends. It depends on the facts. It depends on what argument you're using. It depends on the judge, right? And it does not encourage creativeness. And it's not really all that intellectually stimulating because if you come up with some kind of new theory that's not supported by past cases, you're going to get told you're wrong, right? Men also seem to fare better in the Socratic method than women do because of its confrontational, hostile environment. So we've determined now that to become a profession, there needs to be full-time occupation, check, and we have to have established training schools with university affiliation, check. Now there's local professional associations that need to be started, and we'll talk about that, and specifically the socialization into that profession. So professional socialization is taking on professional attitudes and identity, right? We indoctrinate students into this legal profession. And questions that challenge the basis of that system are seldom raised, right? If I were to go to law school and say, why do we do things this way, though? Why is the Socratic method the way that it's taught? I would be viewed as kind of a radical, right? I would be viewed as someone who's crazy because I'm challenging the system in general. When really law school kind of socializes you to not even question the system because there's so many things you don't understand about the system, you don't even really have the ability to question it. Students are also taught to define problems within the framework of the current system, right? And so that makes students intellectually independent. So the main class I took at the law school was torts, right? And so it was civil law, essentially. And we were never taught why negligence is defined the way it is. We were just taught here is the way people define negligence. Therefore, you must also define negligence because if you don't define it the way I define it, you're not going to do well, right? If I decide to define negligence differently, right, or I look for radical solutions, right, I will not do as well, and class rank matters, and so I've got this huge motivation to do as well as possible in law school. The law is much less about social change and it's much more about conflict resolution. How will we define or solve this conflict, and how will we make it? How will we solve it in an objective way to make sure that it is held up in other courts? In response to some of these criticisms, programs have adopted more joint degree programs. Also. So like UF had a MA PhD program, or an MA JD program with the business school. The criminology department had a PhD JD program where you could get your PhD in criminology while you were also getting your law degree. And it also included a clinical training program. And so it's learning how to work like a lawyer, because the truth of the matter is a lot of people will graduate from whatever school they're from and they won't be ready to actually work in their job. And until they do their job, right? My father's a pharmacist, and he said pharmacy school taught him nothing about how to actually be a pharmacist in practice, right? In pharmacy school, he was drawing chemical structures of drugs and chemical structures of diseases, and he said in his job now, he's literally never been asked by a doctor or a patient to draw the chemical structure of a drug. And so it wasn't until he actually started working in a pharmacy that he really learned how to be a pharmacist, right? The clinical training portion also places students in real-world situations with criminal defense offices or poverty-related neighborhood legal aid offices. And so you're working with your less ideal clients that aren't able to pay all that well. And so you have to come up with ways to defend people that don't have the resources that other people do, which helps students deal with difficult clients and also judges and juries in ways that they won't have to necessarily once they work in private practice, but it helps them come up with it not only helps them appreciate their clients later on, but also helps them, come up with, here's a case you have to work in the least ideal situation. How are we going to figure it out, right? But obviously, these joint degree programs and clinical training portions of programs are more expensive than traditional legal education because traditionally you could put 300 people in a classroom with a textbook and that's it, as opposed to actually finding cases or finding these joint degrees that might benefit. The professional organizations also are present, obviously, in the 1750s. Bar associations initially developed actually as social clubs, and gradually they started to control the admission to practices. Courts also back in the 1750s used to admit people to the bar. After the Revolution, admission standards became loosened and bar associations kind of crumbled. And pretty much only local courts granted admissions to practice. But in the 1870s, lawyers' unions developed. The American Bar Association was formed in 1878, and statewide boards or bar associations were also established. Now, with that, there's licensing and ethics also, right? We've talked about those as points 4 and 5 of the evolution of the profession, right? Licensing is, the quality of legal education, requirements for admissions to the bar, and power of the bar association, etc., all determine your license, right? And it's actually funny because to be admitted to the bar, initially, you have to not have a criminal record, or if you have one, you have to go through a lot of paperwork and interviews and stuff to determine why you have some sort of criminal record prior to being admitted to the bar. Now, what's super interesting, though, is once you're admitted, you could break the law and you might still be able to, it's much easier to maintain your bar association with a criminal record or license than it is to get it initially. There's also professional ethics that are required here, right? And these are guidelines for dealing with clients, other lawyers, the court, and the public. I, in fact, just this morning was on the phone with a buddy of mine who is a civil defense lawyer, and he was working a case where they settled a case against one of the biggest corporations in America for $3,000 because the defense lawyer, my buddy, threatened the other lawyer with breaking ethical guidelines because he was pushing a court to trial that was clearly fraudulent. And once he brought that up and said, you're either going to accept $3,000 or I'm going to have the bar sanction you, I'm going to, take you to court for malpractice, he said, okay, fine, I'll take the $3,000, right? The language is also generally much stronger than the ethical guidelines for other professional associations, right? And that's because ethical questions that relate to the role of the attorney can be very, very questionable, right? If I have power of attorney, if I give my attorney, quote unquote, power of attorney, right, they have complete access to my finances. If, let's just say I was Bill Gates and I turned over my complete financial future to my attorneys, that attorney could say, you know what, I think I'm just going to spend all that money on me now. Attorneys sometimes have the power to decide when the plug is pulled on somebody or not, right? If I give my attorney that power, they can decide if I stay alive or not. So these ethical questions are raised quite a bit. And this is also necessitated by the adversarial system also, right? Because technically, I could go into a defense attorney's office and say, I am guilty, I've committed mass murder, I need you to defend me. I've confessed to my lawyer. Does my lawyer have an ethical obligation to tell the state that so I get arrested or not? That's an ethical question, right? And just to answer that ethical question, an attorney could actually get disbarred for going to the state to tell them that their client did it. Now, in this evolution of a profession, right, professionals must also answer ethical questions on their own, right? Generally, professionals want to do two things, right? They want to be changed and take on the attributes of the profession, while also keeping their previous self intact, right? The profession is viewed as an addition to their life. Now, how might this conflict in the legal profession? It's actually interesting. Everyone wants to be a lawyer so that they can tell everyone, hey, look, I'm a lawyer, right? Isn't it neat? I'm a lawyer. But they don't want to think of themselves as a scumbag lawyer or one of those sketchy lawyers, right? Even though they start taking on maybe some of these attributes of the profession. We would all agree that if you broke into my house and slipped on my wet floor and broke your hip, it's your fault for breaking into my house, right? Technically, under premises liability, though, the person who broke into my house could sue me and win because I had wet floors in the house. A lawyer would make that argument, right? But their friends and family might say, how could you possibly defend somebody like that or sue someone? Like, your client was a bad guy. Well, it's hard to keep your previous self intact when you're taking on these attributes of the profession, right? And this could be very similar or different from other professions like medicine, right? Doctors, are very, very proud to introduce themselves as doctors. In fact, you'll probably find a lot of professors on campus that if you don't call them Dr. So-and-so, they get very offended about the fact that you're not calling them Dr. So-and-so. Yet, they also like to think that they're still themselves. They've maintained their humility in all of this, and they're not special because they have a PhD or an MD or something, right? But they still kind of take on these different attributes, right? There's also some ethical obligations of attorneys, right? Do you treat the symptom of a problem, or do you expand to the root of the problem, right? If your client, if in a criminal case, broke the law because they're poor, do you treat that symptom, or do you expand to the root cause and say, whoa, there's a much bigger issue here of income inequality or poverty in America, right? And the question really is it ethical to narrow down the question to the medical symptoms and answers found in the quote-unquote black bag, as opposed to looking at bigger societal issues? In reading 12.1, we see there's this big issue where there's these mechanisms for professional socialization, right? And there are characteristics of the students that enable this socialization as well, right? And that's because, in large part, right, law school is not really a battle of wills, right, or a contest of wills. Your professor is right, your law professor is right, and whatever they say is true, right? And so the Socratic Method almost kind of beats the student down, almost kind of like a boot camp, to build them back up, right? And so the students, being very insecure and being very uneducated in the law, just trust that their law professor is right and trust that they are just a genius and smart. In fact, when I took torts at UF Law, the professor hated me for the exact opposite reason. He would make all these claims and all these empirical statements and just say them as if they were true, but they've never been researched. And so I would challenge him on them in class and say, what you said is actually counter to research, or do you have research to support the statement you're saying, because I'm not convinced that that's actually true. And he didn't like that because I was challenging him quite a bit, right? Now, granted, I was taking the class pass-fail, and I didn't care about class rank, and so he didn't have as much power over me, right? The other students in the class, though, wouldn't even really talk to me if the professor was in the room, because I was viewed as kind of a troublemaker in the class, right? And the students were so dependent on the professor for approval that they weren't going to do anything to potentially ruin that. And that's why if a student stood up and didn't know an answer, or got called on and didn't know an answer, the students who did know the answer would all shoot their hands up because they didn't care about squashing their classmates to make themselves look better, because they were so dependent on that approval from the professor. In reading 12.2, we see the legal education and the reproduction of hierarchies, right? And it's actually a very, very interesting reading as well, because Kennedy asserts that law schools discourage graduates from practicing outside of the conventional firms that hire graduates from their respective schools, right? And so if you go to a top law school, you're expected to go to a top law firm. If you went to Harvard or Columbia and said, I want to work with the poor in a legal aid, all of your faculty members would say, what is wrong with you? We send people to the Supreme Court. We send people to Congress, and we make presidents. We don't make legal aid lawyers. If you want to go work for a legal aid, go to a bad law school, all right? Because legal aids don't make a lot of money. We make millionaires at our law school, right? And what are some of these legal hierarchies? Well, one I've just already kind of talked about, right? Top law schools send people to top practices. Bottom tier law schools send people to kind of bottom tier jobs, right? Kennedy makes the points that the political values are often fused with the learning of legal dogma. Do you agree with this or not? Do you think that the political values of the law school affect the lawyers that come out of it? It's kind of hard not to agree with that, right? Because I mean, there's a lot of legal debate right now in America, even still, right? The Supreme Court has said gay marriage is legal. Does everyone agree with that? Do all lawyers agree with that? Hell, do all Supreme Court justices agree with that? Obviously not, right? So depending on where you go to school can really shape your opinion on a lot of these political questions that are present. Now, where are we today as far as law schools? Well, in 2004, there was one lawyer for every about 300 people in America, which is kind of crazy to think about because 1 in 300 people doesn't necessarily need a lawyer, right? There are 4 principal subgroups also within the legal profession where people practice. Private practice is obviously the vast majority. Government and private industry are pretty much tied, and then the judiciary, legal education, and etc., right, are the rest of the group. Now, in private practice, there are some significant roles that are played, right? And you will definitely need to know all 6 of these significant roles for the exam, so make sure that you study all of these, right? One of them is the role of counselor, right? You go to an attorney for a course of action in anticipation of the court or the agency, right? I just got arrested. I don't know what to do. Help me. Like, what should I do here in anticipation? Like, will I be charged with this? Will I not be? There's also negotiating, right? This is in criminal and civil cases. There's plea bargaining, settlements that are negotiated, and so your lawyer in private practice will work as a negotiator for you. There's a lot of drafting, writing and revising legal documents, contracts, wills, deeds, leases. My buddy, because he's an associate, he's only been in law school for 3 or 4 years, he pretty much spends his whole day in the back researching, which we'll talk about later, and drafting. Writing up motions, writing up contracts, writing up whatever the case may be, right? Litigating is also another role in private practice. Very few lawyers actually engage in trial work, though. My buddy, again, prepares a whole case for trial and then hands it off to the senior partner who actually argues the case in front of a court, right? A lot of litigation is very, very much uncontested, right? Technically, going to court to file for bankruptcy is litigation, right? But no one argues, no, they can't file for bankruptcy, right? Filing for divorce is also litigation or civil commitment. Criminal charges, sometimes, people will just plead guilty, but they have to still litigate the case as far as does the judge accept the guilty plea or not. Lawyers also do quite a bit of investigating, right? They'll search for facts of the case. My buddy works for a lot of very, very big corporate clients, and so he does a lot of site inspections at various stores across South Florida. And he'll actually go to the store and say, is the store actually operating in an unsafe manner or not? And he'll do some of the investigating. And then, like I mentioned, researching. You got to search for precedents. You got to adapt legal doctrine to specific cases or anticipate court or agency rulings here, right? How does this judge make the decisions? Will the judge buy the argument that I'm making, right? A lot of research is done where it's like, okay, we're looking at the precedent for, like, for example, search and seizure rules. Can I extend that to, let's say, my office? Do I have an expectation of privacy in my work office like I do in my home office because there's a lock on the door that only I have a key to, while me and maintenance have a key to, right? Does that mean I have a higher expectation of privacy or not? Can I extend that privacy right there? In private practice, there's pretty much 3 different kinds of jobs you have in private practice. You're either a solo practitioner, you work for a big law firm, or you're in a partnership with small law firms. And we'll go into all these in detail, right? The solo practitioner is kind of considered the jack of all trades, right? Many deal with collections, personal injury cases, rent cases, evictions, and there's a lot of studies that demonstrate that solo practitioners are the most likely to violate ethical norms, but that's because they have to take whatever work is coming in order to get paid. They are considered much lower status in the profession because of that. They're a jack of all trades, but a master of none, right? The social background combined with the quality of the law school is the biggest determinant of whether a lawyer becomes a solo practitioner or joins a law firm, right? And so typically if you come from a wealthy background and go to a top law firm, you're not going to be a solo practitioner because it wouldn't be as prestigious, right? But if you're first in your family to go to law school and you come from maybe a lower socioeconomic status background, you're much more likely to just open up your own firm because you might not have the ability to get hired by another firm or not. That is, contrast this to these big Wall Street firms, right? These big law firms are dominated by white men. They're very, very slowly changing, but they favor corporate clients. There's a very pronounced hierarchical organization with associates, junior partners, and full partners, and the recruiting centers for higher level government services, right? They're almost kind of looked at as postgraduate training or postdocs, even though they're not technically doctoral students or graduates. But they are pretty much, if you can work for 2 or 3 years as an associate in a top law firm, you have your pick of firms anywhere else, right? You can pretty much go anywhere. This is the kind of firm my buddy works for, just in South Florida, not obviously up in Manhattan. They've got offices all over the place. If you think of Morgan & Morgan, Morgan & Morgan is one of these kind of big firms also, right? Although Morgan & Morgan is a plaintiff's firm, not a defense firm. If I were to list off some of the organizations my buddy represents, I promise you guys all shop there on a very regular basis, right? They have these big corporate clients almost exclusively. What's interesting is that most lawyers don't change from big firm to solo practice or vice versa. Pretty much if you start as a solo practitioner, you're pretty much going to retire as a solo practitioner. If you start in a big firm, you might jump firms around a lot, but you're going to stay with big firms. And these are very much separated by social origins of the lawyers, the law schools they attended, the types of clients they serve, the frequency and type of litigation that they work in, and the different circles of acquaintances. And if you think about it, this kind of makes sense, right? You make all these connections in big firms. If you're going to move, you're going to try and use your connections to move, right? And so you're going to move in that regard, right? The types of clients you serve, if you're used to working for insurance companies, you kind of get in that niche and you become very, very good in that niche. You're not going to suddenly be like, let me try working for someone else now and start from scratch. And so, all of these things kind of make sense. But this hierarchy of lawyers does suggest a corresponding stratification of law into these two different kinds of systems of justice, right? There's this individual and small business system versus corporate system. What happens when this individual or small business, they can only hire these kind of solo practitioners that are jack of all trades, masters of none, not necessarily very good lawyers. But then who do they sue? Sometimes other individuals and small businesses, but a lot of times they sue corporations. Walmart is notorious for also never settling. They would rather pay twice as much in lawyers' fees than in a settlement if it keeps other people from suing them. And so, if you're an individual who's been injured by Walmart and you can only afford a small, kind of solo practitioner lawyer, you're going to have a very, very hard time being successful in suing this big corporation. How you generate income in private practice is also very, very, very controversial, right? There's two different kinds of ways that you bill. You either charge by the hour, which is typically defense work, but there's a large range, right? It might be $50 an hour. You might have to pay $600, $700 an hour, right? And so charging by the hour is very, very expensive. Now, there's a couple things that also might happen, right? Using a heavy pen is what it's called when lawyers bill, right? Because lawyers bill typically in either 10-minute or 15-minute increments. If you're on the phone for 3 minutes with the lawyer, they don't bill 3 minutes, they bill 10, right? And so if you are an hour and 3 minutes, they bill you for an hour and 10 minutes, right? And so those things all kind of add up to where they're not actually, you're getting billed for potentially more minutes. By the time you add all those extra minutes in, you might be billed for several hours over what actual work was done for you. There's also potential for double billing, right? Let's say I was working a case and it was a DUI. I was a criminal defense lawyer. I was charging by the hour and I'm working a DUI, right? The first DUI that comes in, I've got to do a lot of research for, right? I've got to read all the case law on DUIs. I've got to see how different judges have decided things, what the precedent is, right? It might have taken me 30 hours, right, just for sake of argument, to figure out this DUI case. The next day, or after that case is over, I get another DUI case. Is it going to take me 30 hours again to do it? Probably not, right? It might only take me an hour because I've done all the work ahead of time on that other case. Is it fair for me to bill one client 30 hours, but then use all that research I did for the next client that the first client paid for, and then only bill the second client 1 hour? Not really, right? And so what I'll do is I will bill the second client for all those hours of research that they're benefiting from, even though I didn't actually have to do that work again. And that's considered double billing. Now, a lot of people have a huge issue with that and say, well, that's not fair to the second client to have to get paid as much as the first client. Now, that's true, right? But is it fair for the first client to get paid or to have to get charged significantly more because you're just the first case I've ever tried in that? Probably not also. Some people think, well, maybe you should just charge both clients 15 and kind of average it out. But that doesn't work also, because what if I charge the first client 15 hours for 30 hours of work, but I never get another DUI case again? I just have to eat that money? Well, that doesn't seem fair to the lawyer, right? And so, regardless, this charging by the hour can be very, very expensive, and there can be some controversial things that happen. So, what some attorneys have done, specifically plaintiffs' attorneys typically, is they'll do a contingency fee basis. And this is an arrangement where the lawyer receives a percentage of any damages collected in a civil trial, right? And so what they'll say is, okay, and it usually ranges from 30 to 40%, somewhere in there. Good lawyers obviously charge a higher contingency than bad lawyers. And they'll say, let's say I win, just for easy math, I win you $100,000. I get $30,000 as my fee, but if I lose, you don't pay me a penny. So what that does is that feels really good for the plaintiff, because it's like, wow, my attorney's going to be really, really, really motivated to help me, right? Because he's not going to get paid if we don't win. But it might also encourage your lawyer to take a plea deal for maybe $50,000, which your total damages was $100,000. He takes 50, he still gets what? 15,000? That's a good day for him. You might still be, hurting for money, but he at least made it an easy 15,000 that day, right? Are there possible remedies to this? Certainly there are. There's a number of them, but it's also pretty difficult, because could you imagine any other service though that you don't do this for, right? If a plumber comes to the house, they charge you labor. If you go to the mechanic, they charge you labor. Lawyers are willing to take the risk and do a contingency fee, and it might not work out in their favor, but you also might be paying a hefty price for the lawyer once it's all said and done, right? So we've talked about private practice. Now we're going to talk about government lawyers. The majority of government lawyers serve in legal departments for federal and state agencies, like the Justice Department, the Treasury Department, city departments doing zoning and planning, public defenders and prosecutors. There's a very, very small portion that have high executive positions or elected politicians, right? Like Barack Obama had a law degree. I'm pretty sure George W. Bush did. He might not have, though. But, a lot of senators have law degrees, a lot of congressmen have law degrees, right? That's a very small portion. The majority of them work as actual lawyers doing lawyers' work, right? Supreme Court justices or state and federal prosecutors or state and federal judges are lawyers doing lawyers' work. But we'll talk about those more in the judiciary than in the form of government in this capacity, right? Taking positions in the government may be a strategy for upward mobility, because you can segue into prestigious private practice. If you're a clerk for a Supreme Court justice, you can pretty much have your pick of jobs, right? You can gain valuable experience working for the government. A lot of government lawyers are recent law school graduates, but limitations on top salary kind of discourage people from continuing to work for the government. The reason why you gain valuable experience is because if you're a public defender and you mess up a case, does that really hurt your professional reputation? Not necessarily, right? You still got clients coming in, right? Because poor people still need to be represented, right? If you're in private practice and you mess up a case, that could permanently damage your reputation, right? Because you're dependent on word of mouth to get new business. So it kind of lets you, do a practice round for a couple cases prior to actually moving into private practice. There's also private industry that we've mentioned as a 12% piece of the pie. These are salaried employees of private businesses. They're industrial corporations, insurance companies, banks that hire lawyers to kind of be in-house counsel. With increased growth as corporations grow, business becomes more complex, and all these government regulations happen, a lot of people will hire lawyers to make sure we stay in compliance with the law, right? Generally, they don't litigate. And if the corporation gets sued for anything, they typically hire out some other law firm to deal with that litigation. Most will tend to stay in private industry because these are pretty 9-to-5 jobs, right? There's some mobility between government and private industry, not a whole lot though. The people in private industry like it because they're not doing site inspections, they're not dealing with a lot of stuff. They show up to their office in the morning, they leave, they have a nice lunch, they leave at the end of the day, and that's pretty much it. There's no stress of having to go to court, no pressure of having to deal with judges or juries or anything else in private industry. Then there's judiciary and education. This is less than 2% of judges, right? And so there's a very small proportion of lawyers, and these are drawn from the practicing bar, researchers, government service, and teachers. And these are the people that, you know what judges are, you know what law professors are. It's a very prestigious group to even be included in because of their role, right? You're teaching the future lawyers, you're teaching the future senators, you're teaching the future judges, or you are judging the cases. You are having to make a decision that very smart lawyers couldn't figure out on their own. Now, in some questions for thought, de Tocqueville described lawyers as all having the following characteristics: a taste for formalism, dislike for arbitrary power, conservatism. Where do lawyers get these attributes from? Does it happen in their education? And how do these qualities contribute to the profession's function in maintaining democratic institutions? Clearly, right, they get this from their law school, right? But why does it have this taste for formalism and dislike for arbitrary power? Well, it's because our system is based on this idea of precedent, right? It's conservative, it's slow to change. That's what we mean by conservatism here, because we are basing all of our decisions on past decisions. We don't like to have these radical ideas, right? And so because of that, it really happens in the education, right? And it maintains this democratic institution because it's so predictable, right? And we can see what's happening. Now, how are lawyers perceived according to de Tocqueville? Well, it really kind of depends, right? They can be viewed in a very, very positive way, but they're kind of viewed as these people above the rest of us. They understand this thing that we don't understand. And so we have to try and just kind of be submissive to their will and their ideas because of that, right? But reading 11.3 has a very different idea, right? It views the law as a big casino, right? There's two lawyers that are gambling, but they're gambling with other people's money. They're gambling with other people's lives, right? It's like, let's see what happens. Let's roll the dice, kind of like craps. Let's roll the dice and see if I can make some money on this. I might be able to win big, or I might cost my client a lot of money. It doesn't really matter to the lawyer, though, because at the end of the day, in a lot of ways, a lawyer, it's kind of like a no-risk bet. Whenever I go on cruises with my mom always gives my brother, sister, and I money in the casino, right? I'm much riskier when I gamble my mother's money than I am my money, right? Because if I lose it all, I didn't lose anything, right? If I win big, though, you better believe I don't give her a cut of it, right? And so that's kind of like the law, according to the authors of 11.3, Grutman and Thomas, because they view this as they're just gambling with other people's money, right? So I know this was a long lecture. It was longer than normal. Luckily, you guys have the ability to pause it and stuff if you need to stop. But that's all we're going to talk about today. We've only got one lecture left for the rest of the semester, so I will see you guys next time.